Welcome to The Explainer. So today we are diving into the slightly shadowy, absolutely fascinating world of broken contracts under the Indian Contract Act of 1872. We usually think of a contract as this ironclad binding promise, right? A sacred bond that the law is there to protect. But what actually happens when that promise crosses a line? What happens when a deal is fundamentally flawed from the very beginning? Well, today we're going to dissect the anatomy of these broken deals. We're specifically going to look at the critical difference between agreements that are simply void and those that are outright unlawful.
All right, to set the stage here, I want you to imagine a pretty wild historical hypothetical. Picture two highway robbers. They team up to hold up stagecoaches, and they agree to split their stolen loot 50-50. But as thieves often do, one double-crosses the other and just keeps all the gold for himself. So here's the question. Can the cheated robber march right into a courtroom, file a lawsuit, and sue his partner for breach of contract to get his cut of the loot?
Well, the answer to that question comes from a very famous case called Everett v. Williams, and that answer is a hard, resounding no. The law flat out refuses to act as an enforcer for illegal acts. The court basically looked at them and said, look, we're not here to help you sort out the accounting of your criminal enterprise. And this perfectly illustrates a foundational rule. If a transaction is opposed to public policy, morality, or legality, the law is just not going to recognize it.
Okay, let's dive into this. Here is our roadmap for today's explainer. First, when agreements break laws. Second, restricting freedom. Third, void versus unlawful agreements. And finally, can you save the deal?
Let's start with Section 1, when agreements break laws.
Stepping right into the dark side of contracts, we've got Section 23 of the Indian Contract Act. Think of this as your ultimate checklist for what makes the object or consideration of an agreement completely unlawful. If an agreement hits any of these 6 criteria, it automatically becomes void. First off, is it forbidden by law? Things like smuggling or illegal trade. Second, does it defeat the provisions of law, like cleverly drafting a contract purely just to evade taxation? Third, is it fraudulent? Meaning, is it literally designed to deceive someone? Fourth, does it cause injury to a person or their property? Fifth, is it immoral? For instance, agreements promoting prostitution are treated as void by the courts. And finally, sixth, is it opposed to public policy? This includes stuff like trading with an enemy state or bribing a public official. Any deal involving these elements? Yeah, it's dead on arrival.
So why is the law so incredibly strict about this? Well, the doctrine of unlawful agreements wasn't just invented to ruin your business deals. It was developed to protect the public interest and maintain societal morality. I mean, imagine if courts actually enforced contracts for corruption or illegal trade. Judicial enforcement would literally be encouraging those unlawful activities. So by refusing to validate these deals, the law actively prevents the misuse of the justice system itself.
Moving right along to Section 2, restricting personal and commercial freedom.
Now, some agreements aren't strictly illegal, like nobody is smuggling contraband here, but the law still strikes them down because they threaten our fundamental liberties. Section 27 deals specifically with commercial freedom. The general rule here is that any agreement restraining someone from exercising a lawful profession, trade, or business is just void. The law fiercely supports economic liberty. But of course, the law also has to be practical, right? Take the exception for the sale of goodwill. Think about it. If you sell your famous bakery and its amazing reputation to someone else, the buyer can reasonably restrict you from opening a brand new, competing bakery right next door. Because without that reasonable exception, businesses basically couldn't be sold effectively.
Beyond just trade, Sections 26 through 30, along with Section 56, outline a whole bunch of other ways contracts can get voided for restricting freedom or just lacking basic certainty. Under Section 26, restraining an adult from marrying? Void. Under Section 28, you can't force someone to give up their right to go to court. That's a restraint of legal proceedings. Then you've got Section 29, which voids agreements that are simply too uncertain, like agreeing to sell a reasonable quantity of oil without ever defining what reasonable actually means. Section 30 voids wagering agreements, where people are just betting on uncertain future events with no genuine interest other than the cash stake. And my absolute favorite, Section 56, impossible agreements. If you sign a contract promising to discover buried treasure using magic, the law says, well, that's impossible from the very beginning and therefore void. These agreements just totally lack a genuine contractual purpose.
Which brings us to Section 3, void versus unlawful agreements.
Okay, it is absolutely vital to separate these two into distinct legal characters. They sound super similar, but they operate so differently in practice. Let's walk through it. Yes, both lack enforceability, but look at the severity. A void agreement is merely unenforceable, and not necessarily illegal, like making a wager. An unlawful agreement, though, is expressly forbidden by law and illegal in nature, like a contract to commit assault. And because of that, there is a massive difference in liability. Void agreements carry zero criminal liability, while unlawful ones, yeah, those might land you in jail. But the most crucial contrast is collateral impact. Unlawful agreements are essentially like a virus. If an agreement is unlawful, any collateral-connected transactions are also tainted and unenforceable. But if an agreement is merely void, those independent collateral transactions generally remain totally valid and unaffected.
This brings us to a really important Latin doctrine discussed in cases like Sitaram v. Radabai, in pari delicto. This basically translates to in equal fault. When both parties to an unlawful agreement are equally guilty, the courts will generally refuse to grant relief to either of them. The law just washes its hands of the entire situation. And why? Because allowing a wrongdoer to recover their money through the legal process would mean the justice system is effectively assisting in the illegality, and they are definitely not going to do that.
So, the critical takeaway here, which was highlighted brilliantly in cases like Gurulal Parak, is this. Every unlawful agreement is void, but every void agreement is not unlawful. Let me say that again. All illegal deals are unenforceable, but not all unenforceable deals are illegal. A simple wager is void, but hey, it's not a crime. This distinction is what protects public policy while still maintaining strict legal certainty.
All right, our final section, number 4. Can you save the deal?
We've talked a lot about broken deals today, but what if you have a contract that's only, partially broken? Interestingly, the law actually provides practical pathways to rescue a contract. It's a balancing act between strict public policy and the need for commercial certainty. First up is severability, under Sections 24, 57, and 58. If a contract has both lawful and unlawful parts, and the court can clearly separate them, the lawful portion might actually be enforced. Now, if they're hopelessly intertwined, the whole thing falls apart. Second, as we discussed earlier, independent collateral transactions that are connected to merely void agreements can still survive. And third, if the parties are not equally guilty, say one party was heavily pressured or significantly less at fault, the court might actually step in to grant relief rather than just applying that harsh in pari delicto rule.
Plus, we have to look at Sections 64 and 65 of the Indian Contract Act. Principles of restitution totally come into play here. Just because an agreement goes up in smoke and gets declared void doesn't mean it's a total free-for-all. If someone received a benefit under a void agreement, they might be required to restore it or compensate the other party. The law absolutely insists on fairness, ensuring that nobody gets unjustly enriched just because some technicality voided their contract.
And that brings us to our final thought for this explainer. If an agreement is completely fair to both parties and both parties willingly agree to it, should the law ever step in to stop it? Well, as we've seen today, the answer is a resounding yes, because a contract doesn't just exist in a vacuum between two people, it exists within a broader society. And the law has to constantly walk that delicate, fascinating line between giving individuals commercial freedom and protecting the broader public interest, morality, and justice. Thank you so much for joining me to dissect the anatomy of broken deals today. Keep questioning the structures around you, and I'll catch you in the next explainer.